Hello, George.
Good morning, Alsam.
Could you please explain the relationship between the English courts and London Maritime Arbitration?
Sure. Many arbitration practitioners believe that arbitration should be kept entirely free of any court involvement, but that's not the view of the English legal system. London Maritime Arbitration is one of the most successful international arbitration systems, and it owes that success in large part to the supporting role played by the courts. The courts do stay out of arbitration as much as possible, reasoning that if the parties have chosen to arbitrate, they accept they take the rough with the smooth. Arbitration is by no means perfect, but in limited circumstances, the courts do step in. So, for example, unless excluded by agreement, the parties have a right of appeal. That is, appeal on the law, not on the facts. There are fewer than 15 or so arbitrations each year where an appeal is heard, as compared with 1,800 or so arbitrations being started each year. So the right to appeal is tightly restricted, but this means important decisions can be stress tested by the courts. And because English lawyers rely on precedent, parties to arbitration can predict the outcome of their disputes with a higher degree of certainty. An arbitrator is also much less likely to go off-piste if they know there could be an appeal. The courts also have the right to issue injunctions, and there's no doubt a court injunction carries more weight than one from a tribunal. The English anti-suit injunction is not very popular with other jurisdictions and was banned by the European Court of Justice when we were part of the EU. But critics may be surprised to hear that an injunction is not just an English chauvinistic remedy. Recently, one was granted to support an arbitration taking place in Paris. Injunctions and orders can also be obtained to restrain a ship, for example, from undertaking a particular voyage or discharging a cargo. The courts also exercise an administrative role, for example, appointing a tribunal where there is deadlock. But I also want to highlight the English alternative to the emergency arbitrator. When one party wishes to act really quickly, for example, to injunct a sale of something like an oil rig, starting the arbitration process can be too slow. In extreme cases, the courts will step in to maintain the status quo until the tribunal can be constituted. I once made an application to a judge at his house on a Sunday night, and we served the injunction overnight in Asia to prevent a breach of contract. Other injunctions can be for freezing orders or production of documents. These can be real game changers where one party has tended to ignore the tribunal. You'd be surprised at the number of company directors who like to go shopping in London and would come under the jurisdiction of the court. So in summary, the English courts operate with a light touch, but their in-depth knowledge and support of the arbitration process helps London Maritime Arbitration maintain its high standards.
Many thanks, George. Bye-bye.
Bye-bye.